Hello, everybody, and we are so glad that you guys decided today to come to the Moot Court training team for the spring training team session. My name is Austin Boyd. Sorry, I don't have a name tag. It does not stick to this, but it is Austin. So we are so glad that you guys are here today. So what would normally happen for these kind of information sessions is that the executive members of Moot Court would present the slideshow. That's the members who it's not their first year of Moot Court. They've been here for a couple of years and they made their way onto the executive council. But this year we're actually doing something a little bit different where the first year Mooters are on something that we call the professional development team. And we've been training them over the last couple of months this semester to hone their professional development skills, to kind of create slideshows like this, get better at public speaking, and build skills that you can not only apply to Moot Court, but also put on a resume for employers to see after you graduate from college. So yeah, we're going to be allowing those members to present the slideshow today. So we definitely encourage you guys to direct some questions to them, but also at the end of the slideshow, there will also be time to talk to the other members like me and Maitland back there who can also answer questions for you guys. So what are we going to be talking about today? Well, first, we're going to talk about what is Moot Court. We're going to talk about how to write an argument for a Moot Court competition. We're going to talk about why you should join our club. We're going to talk about the case problem. And we're also going to talk about what a tryout for our organization actually looks like. And then finally, we're going to talk about what a schedule looks like, what the timeline is to apply for Moot Court and to try out, and important dates for those tryouts. So without further ado, Mariana, our first year member, is going to take it away and break it down a little bit more.
So what we're first going to start out with is what is Moot Court, which is probably the question you guys all have. So Moot Court is a simulation of legal proceedings in a competitive format. In Moot Court, it helps students with skills like legal research, oral advocacy, persuasive argumentation, legal writing, and speaking skills. These are all really important skills to have and skills you hone throughout your Moot Court journey. So this is an amazing opportunity being on the Moot Court team to engage with lawyers, judges, and professors and just professionals in the legal field. It's also a great way to network. We've had plenty of Moot Court members get internships. Our president last year secured a really good internship with a firm. So there's always opportunities like that. There's also opportunities to travel, meet students and judges from schools across the country. So what is AMCA? AMCA stands for the American Moot Court Association. So the AMCA is who organizes all of our undergraduate Moot Court events. They author the case problems that we argue for that year. So the case problem for this year releases on May 1st. And then what is a case problem? So case problems are meant to simulate real cases brought in front of the Supreme Court, the US Supreme Court. They use fake names and fake case facts, but provide a closed book of real Supreme Court and Circuit Court case law. So all the cases you use in this fake setting are going to be real cases. And then mooters must utilize case law, legal reasoning, and oral argument skills to argue cases. So what is the MCU? So the MCU is our Moot Court universe. So basically, while the contents of the cases are realistic, all of the characters in them are fake. So for example, we have William Denolf. He's usually one of the main people in most of the cases, but we also have the state of Olympus, the 51st state of the United States. We have Olympus State University, and we have Bobby Bronner and Andrea Somerville. We get to be attorneys that represent the subjects of the MCU. And to put simply, Moot Court is college students pretending to be attorneys arguing in front of a fake Supreme Court with appellate argumentation. So why should you join Moot Court? And you should. First, it's really fun and there's a lot of benefits to it. Our team this year has done a really great job of having themed events. We had Partner Day, we did Squid Games for Partner Day. So we did a whole bunch of like competitions and stuff like that. We did the stuff with like I don't even know what it's called, the candy that you like use a needle with. But yeah, that was really fun. Yeah. And then also a great networking opportunity. This year we had Judge Chris Taylor as a judge for one of our scrimmages, which is really cool. So that's just more partner day. These are some pictures of our scrimmages. That was round 'em up. So round 'em up is when we compete against each other, which is really fun. So for Halloween, we threw a Halloween murder mystery party, also super fun. So we always try to throw cool events like that. We also had a Christmas party where we did a Secret Santa. So I went to Columbus, Ohio. That was really fun. I went with Austin. We went to the zoo. We saw gorillas, really cool. And then a bunch of mooters went to San Francisco. And they went to Alcatraz, so that's really cool. And then this is from Los Angeles, Florida, Virginia, and then all of our different hangouts throughout the year. So our team is nationally recognized. We have a great team of mooters. We've had national placements in oral and written advocacy. We have consistently placed at the top 25% of schools in the nation, which is really cool. Many of our mooters have won orator awards, which means that they were the best speaker at that competition. Pre-NACS and national advancements, and last year we placed 8th overall in oral advocacy out of over 500 teams. So there are some requirements for the spring training team. We'll be going over the requirements, logistics, and the advisors. So requirements, you must be an undergraduate pursuing your first bachelor's degree. You must be in good academic standing. You must be a returning student for the 2026-2027 academic year, willing to attend at least 1.5 weekly practices and practice independently. Practices held Mondays and Tuesdays practices are held Mondays and Tuesdays at 5 to 6:30 p.m. at Woon Hall in room 130. You must attend practices, of course, and then intend to try out for the summer provisional team in May when our case problem for this year is released. If selected for the summer provisional team, you must commit to 2 1-hour Zoom practices per week until the August review. If selected for the traveling team, you must commit to 3 hours of weekly practice, plus independent practice as well. So this is a full academic year commitment, so just make sure that you're prepared for that. And then we have our amazing advisors, Adam Witten, Dr. Kimmy King, who was just in here earlier, and then they are really crucial for our success, so please be respectful to them. And then there are a lot of benefits to the spring training team. The spring training team allows you to gain valuable moot skills before May and competition season. As soon as the case drops, you can hit the ground running basically, and you've already learned some of the basics by the time we drop the case problem. So you'll be more ready than some people were this year. I know more ready than I was this year because this was my first year. And then it gives you a competitive edge against those trying out in the summer or fall. So about the case. So the case we are looking at is the 2017-2018 case. This is how you find it on the case through the AMCA website. So you'll go to the AMCA website, you'll click past seasons, previous case problems, and then click on William Denault versus the state of Olympus. And then you just download it and you're done. So what happens in the case? So the question brought before the court is whether the functional brain mapping exam conducted by the state of Olympus facially violates the rights against self-incrimination protected by the Fifth Amendment as applied to the states through the Due Process Clause. So the Fifth Amendment states that no person shall be held to answer for capital or otherwise infamous crimes unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval forces or the militia. So basically, this is the one that protects you against self-incrimination. So about the actual case. So here's a summary. The petitioner, William Denolf, was convicted of murdering Andrea Somerville. This is quote unquote what is said in the case problem. She was a biologist by day and prostitute by night. So she was just doing it for the love of the game. And then during the investigation, Denolf was asked to undergo a functional brain mapping exam. These exams determine whether a person has recollection of a certain place by recording the activity of the brain. Lots of activity indicates that they recognize the place and that they were is a vivid memory. They have a vivid memory of the image presented. When Denolf was presented with an image of a room where Miss Somerville was murdered, he had a lot of brain activity. He had high brain activity. And the petitioner argues that the use of the FBME violates the Fifth Amendment guarantee to the right of self-incrimination. So what does each side entail? So for petitioner, you'll be defending Mr. Denolf. So you will argue that the FBME does violate the Fifth Amendment, and you are asking the Supreme Court to reverse their lower decision. And then for respondent, you're defending Olympus State, the state of Olympus, and you will argue that the FBME does not violate the Fifth Amendment, and you're asking the Supreme Court to affirm the lower court's decision. And then to explain how to write the argument, we have our amazing award-winning mooter, Maddie.
All right, hi guys. So we're going to be diving into how to write an argument. I want to say that sometimes this seems really daunting at first because for your tryout, you have to talk for 8 minutes straight, and that can feel really scary sometimes, especially making sure that you have all of the material and writing everything down, getting all of the case law. But I promise we're going to talk about it right now. We're going to break it down step by step. And actually, after you do that, it can be really fun. It's kind of like solving a puzzle is how I kind of look at it. So first, we're going to talk about some steps that you want to follow before writing your argument. So step one is you really want to understand the case problem. So Mariana showed you how to find that case problem on the website. So looking through that, you want to do just one read through without taking notes, just to get a general understanding of the case. Then after that, you want to make sure that you do a bunch of read throughs to just really fully understand it, this time taking notes. And then whatever your issue is for this tryout, it'll be the Fifth Amendment issue. Then you can get really specific and you can look at just fact specific for your specific issue. And then it's also really important that you read through all of the case law. All of the cases that you will be needing are going to be listed at the very end of the case packet. And so you're going to want to do basically those same steps where you do an initial read through of the case, and then you're going to dive a little bit deeper, kind of figure out the ins and outs of each of the cases as well. Then you're going to want to just take notes and make a note of IRAC, which means issue, rule, application, and conclusion. We're going to dive a little bit more into what that is, but basically it's a formula that you're going to want to use to write your argument. So step 3 is to craft some study tools. Now these can be really beneficial to you so that you can kind of learn how to memorize these case facts, how to memorize all of the case law that you're going to be needing, so you can be really familiar with it, especially if judges ask you questions, then you'll know those things very well. So first tip is to create flashcards to memorize key facts. This is cool because it's really personalized. You can make the flashcards however suits your best studying style. After that, you can create a master doc with notes about the cases, the record, and other important information. This is great because it's something that you can refer directly back to. Anytime that you may be wondering what a case is about, you can look at that master doc and figure out the facts of the case and all the ins and outs really easily. Then you want to brief the cases. Basically, briefing a case is kind of what the name sounds like, where you just make a brief version of the case. Making your own can be really helpful because then you can kind of see what you want to remember and put that into the case. There are some case briefs online, but I recommend that you make your own because the process of creating one really helps you to memorize all of those different details. And then after that, you want to pretend to teach to someone else, or better yet, actually do. You can grab a friend, be like, hey, can I teach you this case law? And then go ahead, run through it, teach them. And if you can teach it, you can argue it. So next we're going to kind of dive into the introduction. The introduction is a small but very crucial part of your argument. It lasts about a minute, but having it memorized, especially for this tryout, can be very beneficial to you. If you sell the introduction with confidence, then you are fully set up to sell the rest of your argument with confidence as well. So we're going to kind of dive into all the different components of the introduction. So first we're going to start with this highlighted section right here and kind of go through it bit by bit. So the first part says, may I inquire who will be serving as Chief Justice? So why do we ask this question? So there will be a panel anywhere from 2 to, I think, 8 judges is the max. And you have to ask who the Chief Justice is if you are issue 1 petitioner, so you can identify who that person is for 3 main reasons. The first reason, if you look right after on Chief Justice may I approach and Chief Justice may I proceed, you direct those questions directly at the Chief Justice. So knowing who they are is imperative. Then after that, at the very end of your argument, if you need more time, let's say they ask you a question and you're running out of time and you can see on the time cards that you don't have time left, then you need to ask the Chief Justice for more time. So it's very important to know who that is. And next, right here on this part of the argument where it says Honorable Chief Justice, Associate Justices, and may it please the court, you want to be able to address the Chief Justice and the Associate Justices. So for example, let's say you're Chief Justice, you're an Associate Justice. Then I would say Chief Justice, Associate Justices, and may it please the court. So you know exactly who you're addressing. Excellent. No, you're good. All right, so now we're going to talk about the small statement part of your argument. So this is basically just a phrase or 1 to 2 sentences that briefly describes the stance that you are taking in your argument. So here it says that you can state the negative impact a ruling has against your position for upkeeping the Fifth Amendment. So this can just be briefly stating your point, the overarching theme of what you want your argument to be and what your stance is. It doesn't have to be super long-winded, just 1 to 2 sentences so that the judges kind of understand what direction you're headed in. And then finally, the last part of the introduction. So this is optional for the spring training team tryout. However, for competition, this section is mandatory, but only petitioner issue 1 does this because they start the argument. So you would ask, would the court benefit from a brief recitation of the facts? Why do we do this? It's so that the judges, if they wish, can listen to the facts again, because sometimes after they've been judging all day, they've heard a bunch of different rounds. Sometimes they forget the facts of the case. So it is your job to tell them. And it's just a very brief summary, very, very simple. It shouldn't be super long-winded. Just explain the facts of the case so that the judges can get a nice refresher on what those are. They can say yes or no to this question, but whatever it may be, if you are issue 1 petitioner, you have to be prepared to answer that question. But for spring training team tryouts, this is optional. So next, we're going to talk about formatting the speech. So this is imperative as it sets up your roadmap. And the roadmap is basically how you organize your argument and how you organize it into different sections so it's really clear what you're trying to argue. So first, we ask the court to reverse and affirm. So what does reverse and affirm mean? So if you are a petitioner, you are going to want to reverse, which this essentially means to overturn the decision of the lower court. If you're a petitioner, you don't like the lower court's decision and you want it to change. Then for respondent, you would ask it to affirm. You like the lower court's decision and you want to keep it. Then after you do that, then you say, after you ask to reverse or affirm, then you list 2 reasons why. These are going to guide the rest of your argument. So there's going to be reason 1, and then here, after you state your 2 reasons, you're going to restate reason 1 so that they remember what that is, and that sets up your roadmap. Then we see these 3 bullet points with case law. All 3 of these are going to be in support of that reason 1. Then we come over here and we see, continuing to my second area of analysis, you're going to restate that second point, and then you're going to list your bullet points with case law. So this really shows how to organize your argument, get it really clear so the judges know exactly the direction that you're going in. And then at the very end for the conclusion, no need to do a really long-winded conclusion, just simply wrap up by saying, for these reasons, we ask that you reverse or affirm, depending on your position, the decision of the lower courts. So now we're going to go over some case law basics and what that looks like. So basically, case law is a body of law developed from judicial opinions or decisions over time. In other words, it's exactly what we use to form our arguments. We couldn't have arguments without case law. So what are you looking for whenever you're reading through case law? First and foremost is major holdings. What has the court decided and how does this apply to your argument? Next is any useful precedent, what other courts have decided. And a lot of the time, all of these things kind of overlap. You'll be reading a case and you'll see a case that you might already know being mentioned by one of the justices because all of these cases build directly on top of each other. And then important rulings. So what new rules did the court create? How can I use these in my argument? Next is that it's really important that you build your argument off of really good case law because this will create really strong arguments that'll be really hard for opposing counsel to argue with and counter. And so what is good case law? How can I find it? There can be a lot of ins and outs and a lot of intricacies to finding case law, but mainly you want to find any case law that furthers your argument. Anything else doesn't help you, and so you want to just focus on things that help your issue and your argument. So we're going to be kind of going through an example of case law. This is one of the cases. You've likely already know what this case is, or at least have heard of it. If not, you probably know what the rulings are. You just don't know the name of the case, because this is the case that basically decided that if an officer suspects that you have been drinking, then they can take a blood sample. So I want you guys to take a second, briefly read through the facts of the case and the issues. We're going to do like a little activity to kind of, figure out how to identify certain things that you might want to use in your argument. And so go ahead, take like 20 seconds and read through those, and then we'll reconvene. We good? Okay, so I'm just going to briefly kind of talk about what these issues are saying in short so you can kind of understand it. This first one is just about due process. The second issue here is about the right against self-incrimination. The third is about right to counsel. And the fourth is this reasonableness of searches and seizures. So here are the holdings, and all four of these holdings correspond to the four issues that I just discussed. And so this is what the court decided in this case based off of those four issues. So what I want you guys to do is go ahead, read these as well, and then pick two that you think are beneficial to Denolf's case, just based off the brief facts that we talked about earlier. It's okay to like make mistakes. This is the hard part about reading case law. So just read through it, maybe think about it, and then I will ask some people what they think. Does anybody have any ideas, just like skimming through it and reading it? Yeah, which one?
I-44 is a really good example because obviously the police officer's responsibility is to make sure that he is safe and
Exactly, yes.
while he's driving. So the fact that you smell his breath, that he had a right to check him to make sure that he was or wasn't, in order to see if he's able to just keep driving after the accident. Well, obviously he was.
Right.
But just for that whole entire situation, so his rights wasn't really taken away because he was on public road also.
Right, and that's a great one to identify because number 4 is really, really helpful with the Denolf case specifically. This reasonableness test that is in this case is exactly applicable to Denolf's case on the first issue. Does anyone else think they know what the second one might be? Yeah.
That's what I was gonna say.
Yeah, perfect. Why do you think so?
I think because there wasn't any, I mean, it kind of just says it for me, is that there wasn't any. To protect yourself, there has to be something that you're protecting.
Right.
And you're not protecting yourself from that, if that makes sense.
Yes, exactly. So number 2 is the other one that's really important to Denolf's case because this one talks about self-incrimination, which is basically the entirety of the first issue for this case problem for 2017. So great job. You guys applied all of those. So now we're going to be taking one of those, specifically the self-incrimination issue, and we're going to look at the IRAC formula. So the I stands for issue, the R stands for rule, the A stands for application, and C stands for conclusion. So the issue here is about the compelled physical evidence under Schmerber or unconstitutional compelled testimonial evidence. So these two are important to the self-incrimination idea and for this issue. Then the rule here is what did the court say? What rule did they set? And so that is Schmerber versus California permits compelled physical evidence. Fifth Amendment prohibits compelled disclosures revealing the contents of the mind. So this also references 2 other cases that are also important. And then there's the application. This is whenever you actually take what you read from the case law and apply it to Denolf's case. So here, these are all the applications, how they kind of work hand in hand. And then finally, the conclusion, the final, what did this case say? How does it apply here? And then next slide. And so this is going to be an example of what this will look like in your argument. So you basically take the IRAC formula that we just looked at on the slide, you flesh it out, you make it a little bit longer, you kind of explain it a little bit more, but as you can see, it follows that exact formula. You list the issue, you talk about the rule, then you make the application. How does this case apply to Denolf's case? and then you conclude. So this is exactly how you're gonna kind of want to go about this within your argument. This should take about 1 minute each per section. So you can go next slide. So how exactly does this fit into your argument outline? So like I said earlier, you do want to break down how you do this into little small bits. So doing Iraq creates about a 1 minute section of your argument. So this breaks it down perfectly so that you can just stack those on top of each other and make sure that your case law goes directly into whatever your first and second reason are and that they match up so you can have very clear organization of your argument. But as you can see, this was the exact wording from the previous slide that makes exactly 1 minute. It goes straight into that portion, and then there you go. You have a whole minute of your argument. So you just do that, repeat that, and that's how you get an entire argument outline. If a judge asks you a question, that's totally okay. That doesn't have to, the time isn't exact, but that's kind of just a general rule that you might want to follow. So now we're going to go over what tryouts look like, and I'm going to call up Talasi, who is an incredible mooter and who has successfully gone through this process. And so she'll be able to tell you exactly what they look like and how you can handle them.
So I'm going to be talking about what's probably the most nerve-wracking part of all of this is the actual tryout. So the tryout overview. For spring training team, it's basically you going to be preparing this 8-minute argument on either the petitioner or respondent side. If you will learn about the skills that are needed for the summer team and the fall team. So the tryout's actually going to look a little bit like this. You're going to be behind a podium and judges will be asking you questions and taking notes on your argument. Before that, there's going to be a little bit of an interview process where judges are basically just going to ask you about scheduling, your availability, and other information that's going to be important to the spring training team. We're going to be judging using the AMCA ballot, which I'm going to go over in depth a little bit later. So how do you book a tryout? You will be completing the spring training team form. You're going to be sent an email. Book early, there's only 24 spots available. So double check, triple check that we have your contact information correct. So you can get that information and sign up as soon as you get that. Answering judges' questions. That's also probably a really nerve-wracking part of tryouts. Judges aren't asking you questions to break you down or kind of humiliate you on the podium. They want to test the validity of your argument. They want to test your roadmap. They want to test your research skills. So like Maddie said, thinking of writing your argument as a puzzle, actually saying your argument, you want to think of it like a conversation. You want to help the judges understand your side based on all of this research that you've done and all of this writing that you've done. It's okay to take a beat and think about a question. It's okay to pause, not for too long because you are on a timer, but you should just take a beat, take it in, and try your best. As you go through the summer team and the fall team with all the cases that you learn and all of the training that you do, you build a bank of knowledge that you'll essentially be able to take out ideas from and answer a question in full. Saying something is better than not saying anything at all. So what does this look like? For example, when you answer a question, you want to go, Chief Justice Boyd, 98% of Americans believe that pineapple does belong on pizza. This is outlined in the case of People with Taste Buds versus Big Pizza, and it is highlighted on page 3 of the record. So to break that down, basically you're front loading, you're saying, yes, I agree with your question. This is basically how it connects to the case, and then giving case law, citing the record, all that stuff. So formalities. Try not to fidget around. In the fall, something we really work on is no movement. You want the judges to focus on what you're saying and not what your hands are saying. So don't do what I'm doing right now. Say yes or no, Your Honor. Like in the example, you just want to immediately say how you feel about their question, because judges, they just want to know how you're thinking of it. And when with something in a time constraint, they want to know, they want to follow your roadmap. They don't want to be confused. So let them know what you're thinking. Followed by the explanation. We don't use personal pronouns. We say we hold, the respondent, petitioner argues. Moot court is a partner sport. So you're going to be with a partner, you're a team. If you mess up, take a deep breath. It's going to be okay. Keep it professional and don't apologize. Judges sometimes don't even recognize that you made a mistake, but as soon as you say like, oh my God, I'm sorry, you're calling attention to it and they're like, oh, she messed up. So fake it till you make it. That's part of it. And this is the official AMCA ballot. You're going to be graded using this rubric in your tryouts in actual competition. It's 400 points total, 100 points for knowledge of subject matter, 100 points for response to questions, 100 points for forensic skill, courtroom logic, and 100 points for the clarity and organization of your argument. In tryouts, we're also going to be looking for other soft skills, your professionalism. Does it seem like you actually took time to research into all this? So make sure that you want to present those to us when you try out. Here's a little bit more in depth about how to prepare for tryouts, read the material, run often, time yourself, also record yourself. That is the best way to find your strengths, your weaknesses, and on answering questions, when you record yourself, you automatically hear the gaps in your argument. So you're going to be able to prepare responses for those possible questions, prepare transitions, because when the judges are pelting you with questions, you're going to have to return back to your argument and you want to be able to plan those pivots. Start your prep early and make sure you can bring physical materials. So, make your notes, but make sure you aren't reading completely on a script. Craft a resume, print your class schedule. You're going to be turning in your resume at tryouts and your class schedules just to make sure there's no conflicts. This QR code goes to our link tree. There's going to be the Harvard resume template, so you can use that as a good guide. And an everything you need to know doc with instructions that were all over here and how to get started in your argument. Next one. Oh, and you will also be receiving these slides. So make sure you have your contact information all correct so you can get these. Okay, schedule and important dates. You can also make sure to take pictures of this. You're going to get all this information. It's also in your handouts, but this is kind of a general idea of what's going to be happening. Practices are going to be Monday or Tuesday. You will receive that with your acceptance, the case problem, and then the summer and fall tryout schedules. So life after tryouts, your practices are going to be Mondays or Tuesdays. You'll be notified. Weekly attendance is required. Your skills are building on top of each other and preparing you for the summer and fall. So we want to make sure that we're getting everything. Expectations within practice. These are consistent whether you're a returning mooter, a new mooter, or you're an exec. You want to be on time, be fully present and engaged, handwritten notes, attention and professionalism when your peers are running, and receiving feedback from execs with an open mind. Outside of practice, you will have to spend time, especially during competition season in the fall, formulating your argument and practicing runs. Come to practice ready to meet benchmarks, some notes, no notes. And this isn't consistent. I know personally in the fall, when there was a couple weeks where I was really struggling with petitioner. And so I had to spend extra hours outside of practice to make sure I'm coming to the next one ready. So it's all in flux, but you will have to spend time outside of practice communicating with the team about absences, late arrivals, or anything you're struggling with, because ideally we should be able to help you out. If you need extra help reading with case law, I'm not going to go over all of this in depth, but this is another system that we have to read through case law and make sure you're getting all the important stuff out of it. This was taught to us by our amazing faculty coach, Adam. So in moot court, not only are you speaking like this, but you're getting a lot of this like really important legal education that a lot of people really only get when they go to law school. So this is like really important. Here is the acronyms broken down more. IRAC, which Maddie did a great job going over. So for this one, the LAD, it's facts, issue, the legal principles, application, decision, and dissent. And it's like a more expanded version of IRAC. So this is an example of how you would use this. Facts, it's very brief because you really want to get like the meat of it. Within Supreme Court cases, there's a lot of extra stuff, but you really want to make sure you're focusing on the important parts and how that applies to your argument. The issue, the legal principles, application, decisions, and dissent. And dissent is like, what do the people who disagree with this? So I'm gonna call our amazing president, Adam, Austin Boyd, or not Adam, to give some concluding remarks.
Yes, so amazing job to Leslie, Maddie, and Mariana. They all did an amazing job, and that's kind of a hint of what you guys will get if you guys join the team. Not only will it be moot court focused, but it will also be professional development focused. So yeah, these are some pictures of me with the organization. This is only my second year, and I've already, as you can see, had so much fun and so many good experiences. Not only just fun times, but also lots of learning was done. A lot of these pictures are me at competitions. These two are me and my partner Sean. That one is with the entire moot court team at our scrimmage here in Wooten Hall. This is also with Sean at our Christmas party. And this is at our Halloween costume party, which we made sure to send everybody away if they didn't wear a costume. So you guys beware, you might have to wear a costume. But yeah, so really before I joined moot court, I was kind of shy. I was in a STEM academy for high school. I was 100% sure I wanted to go to school for engineering. That's just what I knew I wanted to do. And then whenever I signed up at UNT, I was like, you know what? Like, I don't know if that's really for me. So I actually changed my major to political science. I kind of joined the pre-law campus and heard about moot court. And guys, I had never heard of whatever the heck a case law is. Nobody had ever explained that to me. I didn't know anything about the legal profession, but I just thought that the case that I read sounded really interesting. So really all you guys need to try out for moot court is not, exactly how to know what your argument is. You just need to think, oh, that case that they read the summary of, that sounds kind of interesting. I kind of do want to argue about the functional brain mapping exam, but let me learn about how I can really get an argument about that. So really what moot court is about is not about being a professional when it starts. It's about putting consistent time and effort into learning those cases, into learning what the Denolf case is all about, and ultimately getting your argument for it. So this is our QR code. I think this is the same one from earlier, but if you guys want to scan it, if you haven't already, this is our link tree. It has lots of important documents like how to try out and a lot of the stuff that was presented in the slides. But again, you guys will be receiving a copy of this in a little bit. So thank you guys for coming so much, and I would be overjoyed if any of you guys had any questions about literally anything. Could be personal, could be about how to write an argument, could be about the moot court universe. So do you guys have anything that you might be wondering about? Yeah.
So out of tryouts, how many people actually make it to the team?
So there's not a guaranteed number right now. It kind of just depends on what we see from you guys, but it will generally be probably somewhere from like 6 to 8 people. It could be a little bit more or less, but that's a solid range that we're looking at.
And we're mostly doing that because we're having Monday, Tuesday practices. So we'll be able to get through maybe 5 arguments a day and be able to give helpful feedback. And we don't want to take on too many people where people aren't getting any practice or training in. So if for some reason we have like 20 really great mooters, maybe we'll talk about expanding and see what we can do. But right now that is the number we're kind of looking at.
Yes, just want to make sure for the slide, when do you think y'all can email it to us?
So I'm getting together, once this video recording is done, I'm going to put it together with the slideshow as well and send out a PDF of the slideshow along with the video if you need to go back to what someone said and see the expansion on it. I'm hoping to get that done tomorrow, but I also got school to do too, so don't hold it against me if it's maybe Thursday. And as long as you were signed up on the RSVP for this event and you also checked in, if you're on either of those, you're going to get that email, so don't worry. Thank you.
Yep.
I know one of you mentioned spending time outside of class and outside of your meetings to prepare for your practices. Do you have like a general number of how many hours you would recommend spending outside of the meetings to prepare for the cases?
Yeah, so really not a lot. I don't want to say it's a super low number and give the impression that it's not something you need to work for, but in general, I would say outside of the 3 practice hours that you will have to attend if you make the competition team, I would probably spend an hour or 2 at most per week on moot court outside of practices. That's just to make sure, because we have benchmarks that we want to get to by competition season. Like you would, try out with notes, and then maybe 2 weeks later you have only bullet points, and then 2 weeks later you have no notes. So it will probably take you 1 or 2 hours a week to get off of those notes, but the majority of practice and time doing that kind of stuff will be in practice and not outside of practice.
To expand on that, I feel like too, starting off, you practice a little bit more because you have to read all the cases and things. So if you feel like when you're creating your argument for your tryout that this took a little while, that's fine. At first, it's going to take a little bit longer since you're reading cases and also trying to understand. But the more you do moot court and the more you read these cases and break them down, the easier it's going to be, which is our hope of the spring training team. So if you want to try out for the summer provisional team, by the time that case drops, you're going to be reading those cases a lot faster. You're going to be really surprised how just doing one argument has already made it where it's so fast. Now I could really probably like create an argument by myself like in an hour or two, and it's quite impressive because it probably took me maybe like 30 minutes to an hour just to read a case the first time. So don't let the first argument get you down if it takes a little bit longer, okay?
And speaking of the summer case drop, we tried to do this last year, couldn't because they moved the time. But what we're gonna do this year is everybody, especially, or if you guys get on the spring training team, you'll be invited to this as well. We're gonna do a midnight Zoom call and whatever they.
It's not midnight
Oh,
anymore.
never again? Never again?
To do midnight, and we were all gonna talk to each other at midnight, but now they're doing, like
Every
11
year?
a.m. Yeah, they changed it,
That's
so.
ridiculous.
I don't know, they could change it again
That's
this year for
ridiculous.
all we know.
I hope they do. I'm gonna call
It's
them.
May when we're doing it, but we'll do a case drop party and all get to be together in some form if you're interested and read it for the first time and give live reactions. Yeah,
It's like the ball dropping on New Year. It's very fun.
for moot court, yeah.
Any other questions, guys?
So to try out, do you have to be available throughout the summer?
Yeah, so basically so the first, like, think of it like level 1 is the spring training team. That is only an hour and a half a week. That's just one practice session a week. And then in the summer, it is 2 1-hour Zoom meetings a week. So we're only asking for 2 hours of in practice time, plus, the whatever extra you need to spend outside of practice to get ready. But yeah, it's only 2 calls a week, 1 hour.
And we
each.
know that a lot of people go on vacations or they have work or other commitments that they have to do over the summer. And we're understanding of that if you need to take a break. But we also have mooters like me. I was on my honeymoon in Japan in a different time zone on practices at 2 o'clock in Japan time because I didn't want to miss out on moot court. So we have a lot of people that do that. But if you can't do that, we understand. You just have to communicate that. But that's specifically for the summer. Does that help answer your question?
Sort of.
Sort of. Why don't you talk to
Yeah.
us afterwards and we'll find out your specific situation, okay?
Go ahead.
For tryouts, do we have to dress a certain way?
No, some people do. I'm not really a fan of telling people that they need to like dress professionally. I don't know if your opinion on that would be different, but I don't think that.
To have business casual on because I think that whenever you're going to an interview, since this is a pre-law program, we're setting you up for success in your future careers. And whenever you dress business casual or something, it really does elevate your mood and your confidence, and it shows your commitment to the team. So if you're unable to, maybe you've got a sports event that day or something and you've got to come or whatever, we're not going to hold it against you. But I will say that it does just add that little bit of extra oomph to your tryout, if that makes sense.
It definitely doesn't need to be like very formal, like what I'm wearing right now, but it can be
Yeah.
maybe not just a t-shirt and shorts.
Casual is what I'm wearing right now.
Yeah, somewhere.
Yeah, we didn't.
You can average it out.
Yeah.
Yeah.
I dressed like that yesterday and no one else did, and now today I'm like, no.
Change up.
And I add to what you said, it's the same that goes, dress good, feel good, and you do good, so.
That's very true, yeah.
Anything else, guys? No? All right, well, we're all going to be here to chat afterwards for a little while. So if you guys want to talk to us individually, you're more than welcome to. Please take food to go. We would be more than happy if you guys had extra to go. And thank you guys so much for coming. We really hope to see you guys try out for our team soon.
I'm serious. While you're walking out, grab a pizza box. Take a pizza box. We don't care.
Literally,
You're
whole
college
box.
students. You've got
Yeah.
lunch for a week.